Welcome to the Senior Safety Advice Podcast, your trusted source for expert guidance on aging safely and independently. Whether you're a caregiver, a family member, or a senior looking to stay secure at home and beyond, we've got you covered. From fall prevention and home modifications to financial safety and scam awareness, we provide practical tips to help you or your loved ones live with confidence. Tune in and empower yourself with the knowledge you need to navigate the challenges of aging. Let's make safety simple.
Hello, everyone. Welcome back to the Senior Safety Advice Podcast. This is episode number 13. Today, I wanted to talk about legal planning for seniors. This is really for older adults, but it's also for family members of older adults. Now, when my husband passed away suddenly, I was thrown into the legalities of what it means to die. There were a lot of issues that had to be ironed out. I mean, thank goodness he had a will. I have a will too. We created our wills when we got married, so that was very helpful. In the state that I live in, because we were married, there weren't any issues. I didn't have to go through probate, but the car was in his name. Other things, credit cards and so forth were in his name. Airline credits or points, whatever you call them, were in his name. And some things I could not legally take. They had to be closed down or I lost them, like the airline points. That was ridiculous. Anyway, there's a lot of little details and issues that come up when someone passes away or if they become incapacitated. So I think personally, if you want to be in charge of what happens if you become incapacitated or when you pass away, then I say do as much as you can as far as legal planning goes. So I'm going to give you just some basic tips here. I'm not an attorney. I recommend that you go to an elder law attorney. Everyone should have an elder law attorney because personally I think everyone should have a will, especially if you have children. But there are other documents also that need to be put in place in order to make your wishes and desires adhered to. So we're going to go over some basic things here. So the first thing I want to talk about is estate planning. Now, estate planning is basically the process of arranging and preparing all of these legalities that need to be taken care of if you become incapacitated or when you pass away. And I say when because everyone's going to pass away. There's no getting away out of it. There's no getting out of it. Estate planning basically involves creating these legal documents like wills and trusts and powers of attorney. Yeah, there's more than one power of attorney. Just to make sure, like I said, that your wishes are carried out, that your assets are distributed like you want them to be distributed, and that any potential legal or financial issues are minimized for the family who's left, the people who are left. You want to make it as easy as possible. So we're going to talk about wills first, because I think that's the most basic thing that you really should have. A will, sometimes it's called a last will or a testament. It's a fundamental legal document. I mean, everyone should have a will. Everyone has a birth certificate. Everyone should have a will. It outlines how a person's assets and property should be distributed after their death. And it serves two basic critical purposes. One, it specifies the asset distribution, who gets what. And it appoints an executor, meaning it appoints someone to manage it, to handle it. Now, you want to be careful when you choose your executor. My mom-in-law passed almost a year ago, about 10 months ago, and my sister-in-law is the executor of her will. and she is about 90% done with all the paperwork that needed to get done for my mom-in-law's will. Now, we're not talking about a billionaire with multiple properties or anything like that. We're just talking about a 102-year-old middle-class beautiful woman who had some savings. But that's how long it can take to execute a will, depending, of course, on how many people she's distributing things to, any homes, properties, whatever. But my point is that you want to choose someone who can manage this type of work. It's not easy, but so you want to get someone who's responsible and who can take care and make sure that your wishes are adhered to. So that's just my little tip about an executor. But a will is extremely, extremely important. And yes, I know it costs a little bit of money to go to an elder law attorney and to get a will done, but it's absolutely worth it. It's 100% worth it. So please do it, not only for yourself, but for your loved ones as well. What happens if you don't have a will? Well, if you don't, the state that you live in determines the distribution of your assets. So every state has different laws. So if you want to find out what your state, what their laws are, you can certainly go ahead and do that. But basically, they will then determine who gets what. You obviously will not have chosen an executor. A court-appointed executor is then established for you. There is a probate process. A lot of people that have died, families that have had a loved one die without a will tell you the agony of going through probate, which basically means that the estate has to go through a court-supervised process to settle debts and distribute assets and all of that. And this process can take an extremely long time. So even if you were going to receive any assets at all, it may take a very long time to get those assets. Exclusion of non-relatives. Typically, the states do not recognize a non-relative as receiving anything from your assets. So if you wanted to leave anything to a friend, a partner that you weren't married to, anyone outside of your immediate family, they will not be able to get anything because a state distribution does not normally allow for that. And then if there are minors involved, the guardianship for minors then will be laid on the court. The court will then decide who becomes their guardian, which may, of course, not align with your wishes. Maybe you want, Aunt Mary to be the guardian, but instead it's going to be, Aunt Elizabeth, who you don't get along with, or you don't, like the way she, her belief system or values, or I don't know. Anything could possibly happen. But the point is, if you don't have a will, these are the things that can happen. And they don't seem important when you're in your 20s or your 30s or maybe even your 40s. But as I said, if you have a birth certificate, you should have a will. As soon as you can say what you want to happen to your stuff and to whom should get your stuff, you should go ahead and establish a will. All right. Trusts. What are trusts? A trust is basically a legal arrangement where one person, usually called the grantor, gives another person or an entity called the trustee the right to hold and manage assets for the benefit of the third party, which is the beneficiary. Lots of legal terms. Trusts are basically used to manage and protect assets, really, at the end of the day. They ensure that they're distributed according to the grantor, the owner of the trust, wishes, and they avoid a lengthy and costly probate process. After my husband passed away, I went ahead and put everything that I own in a trust. That way, if anything happened to me, or when something happens to me, my executor and my family and friends and everyone that I've outlined who I want to receive anything will not have any problem receiving it, and they should receive it quite quickly, within a couple of months, hopefully. There are 4 types of trusts. Revocable trusts, that's the one that I have, and this is where I have the ability to revoke the trust at any time during my lifetime. So I can establish this trust, but then I can change it if I want to later on. That's the one that I chose. Irrevocable trusts are, once they're established, that trusts cannot be easily changed or revoked. They offer benefits like asset protection from creditors and potential tax advantages, make them suitable for long-term planning, but you won't be able to change them. So I think, depending on how old you are, I think if you're older, an irrevocable trust may be better for you. A revocable trust may be better if you're younger, in your 40s and your 50s. You can speak with your elder law attorney about the pros and cons of both of them. And of course, with a revocable trust, if you start off with that, later on as you get older, you can then convert it to an irrevocable trust, or basically create an irrevocable trust. A living trust are created, again, while the grantor is alive, and they allow the grantor to manage the assets of that trust during their lifetime, and specifically how the assets should be distributed after death and so forth. It goes along with the will, what is in the will, who you want to get what. A testamentary trust are created through a will and only take effect after the person's death. They're often used to manage the assets for minor children and other beneficiaries who may need assistance. Maybe there's an adult child that is mentally disabled, or is unable to manage their own assets for whatever reason. Then a testamentary trust would be what would be used in that case. Again, speak with an elder law attorney about which one would be best in your situation. Power of attorney is another document that is extremely important. Most people will go ahead and create a power of attorney, but you have to realize that there are 2 main power of attorneys. One is a medical power of attorney, and this allows you, as the person who has the power of attorney, to talk to their doctors, to decide what medical procedures they should have, to choose where they'll receive care, like a hospital or a nursing home, and to ensure that their wishes are supported. A financial power of attorney, again, allows that person who has the power to pay bills, to manage bank accounts, to file taxes, to sell or rent property, to apply for benefits and Social Security or Medicare. Basically, a power of attorney gives this other person that you assign, you're trusting that person to take care of you, either medically, financially. Maybe in other ways too, but those are the 2 main basic power of attorneys. Again, an elder law attorney can go more in depth, but those are the 2 basic issues, and those are the 2 I think that are most important for most family members. Advanced directives are yet another form. See, there's a lot to do in legalities for if we become disabled or when we die. A living will. I have a living will. It's a written document that tells doctors and your family, or anyone, who you assign to be your executor or power of attorney, what kind of medical care you want if you're seriously ill, injured, if you can't talk, you can't make decisions. It covers things like whether you want life support machines to keep you alive, or if you want certain treatments like CPR or feeding tubes. It's a guide, basically, for your doctors and your family to know what to do if you become incapacitated in a way that, because their role is, at least the physician's role, is to keep you alive. So if you don't want that, if you don't want to be in a coma for the next number of years, if you don't want any of that, then you have to make your wishes known. A healthcare proxy is a document where you choose someone that you trust, hopefully, to make medical decisions for you if you're unable to do so. So this person is basically legally called your agent. And it's very much like the power of attorney for medical purposes. This works alongside a living will. I'm not sure if you need a medical power of attorney and a healthcare proxy at the same time, but I know I have a living will, and I know I have a healthcare proxy. So probably until I assign someone a power of attorney, I'm not sure, actually. So again, consult with your your elder law attorney, and they will help you through it because they've seen every scenario that could possibly happen when you have things in place and when you don't have all these things in place. So I do want to tell you a little bit about what an elder law attorney does. It's not just a regular attorney. It's an elder law attorney that has a specialty in this area of estate planning. So they can help you to plan for the future, like making wills and trusts. They advise you on how to pay for long-term care, for nursing homes. They can help you through all of that. They assist you with getting benefits like Medicaid and Medicare. They protect adults from seniors from abuse or fraud. They help set up powers of attorney so someone can make decisions for you if needed. They guide families through the whole mess of guardianship if an older person can't make decisions, and believe me, it's a mess. When I worked as an occupational therapist, I worked in geriatrics for 12 years. I saw so many families go through basically, not only are they going through the emotional issues of watching their senior loved one, dying, but now they're going through all the legal and complicated issues of dealing with things that were not set in place ahead of time. And it can be extremely difficult and frustrating whenever you have to deal with courts and lawyers and all of that. So do it ahead of time. It's very important, I believe, to use an elder law attorney because they know all about the special laws that affect seniors, older people, disabled people, anyone that may be needing may be incapacitated, anyone like that. They know those special laws. A regular attorney may not. They can help you save money, basically, and protect your assets. They make sure an older person's wishes are followed. They help families avoid arguments about care and money. And believe me, as much as you may think your family is close, care and money can tear a family apart. I've seen it dozens of times. So avoid that. They know how to deal with complex government programs, which you definitely don't want to deal with. And they can spot and prevent elder abuse or exploitation. They are your best friend as you're growing older. So get yourself an elder law attorney. Go through this process. Get these documents in place. They can help you. All you have to do is walk in, tell them your story, and they will get you started. And it will be worth every penny. The peace of mind that it gives you it's wonderful. I felt very good when I signed my papers and everything was done. And I knew that no matter what happened to me, that my executor, my family, my friends, everyone that I've assigned anything to would be able to take care of it without having to worry about, who's going to do what, how's it going to happen, any of that. So anyway, I hope this information was useful. Again, I'm not an attorney. I'm just telling you what I went through myself and just giving you the basic information. Speak with an elder law attorney. They will help you tremendously. And I thank you so much for listening. I look forward to seeing you next time on episode number 14. Thanks. Take care.
That's it for today's episode of the Senior Safety Advice Podcast, helping you and your loved ones stay safe, independent, and informed. If you found this episode helpful, be sure to subscribe and share it with others who could benefit. For more expert tips and resources, visit seniorsafetyadvice.com. And remember, staying safe starts with staying informed. Until next time, take care and stay safe.